I think when you love something so much and when you're touched and moved by something like as deeply as I was by this book, it just kind of comes naturally. It comes from the heart, hits the heart, and that's kind of what kept me going throughout this whole process, is just knowing that we're working on something special that has the potential to impact millions of lives.
Hi, besties. So, Blake Lively thinks she has the perfect case, and she is in the middle of discovery. She's going through all sorts of motions to compel, and it obviously, for many, looks like she's winning because the judge keeps granting all of these motions. But be hopeful, my friends, because judges, specifically in cases of employment feuds and discrimination, and where the plaintiff may be a possible victim, they do not like to appear as though they're impeding in that person's ability to prove their case. And so, on the face, they are allowing her to get the discovery she seeks, but that doesn't mean that the discovery she seeks or that he's granting her to have means that she's going to get the evidence that she needs. All right. And what really matters is if her case can hold up under the rule of law, under a motion to dismiss, a summary judgment, or even going to a jury trial, right? And she thought and she thinks she has the perfect case, right? She's claiming she was harassed and retaliated against, and a smear campaign was designed to ruin her reputation. I think what Blake failed to consider was Jed Wallace, because Jed Wallace and his attorneys are being masterful in how they are navigating their motion to dismiss and how they are systematically dismantling her entire case against him and even poking holes in the strength of her case against everyone else. Jed Wallace is not a Hollywood mogul. He was not a part of the film. He is not her employer. He was a agent, a PR agent consultant that was hired, and he's right now in federal court in New York. And he is going line by line, allegation by allegation, and he is dismantling her case. And they're not doing it with theatrics, they're doing it with cold legal precision. His lawyers wrote this in their latest reply. Her two-paragraphed attempt in a 31-page brief to overcome defamation exception is hardly a response at all. That's his tone throughout the entire response and his defense. It's clinical, it's pointed, and it's relentless, you guys. And over this video, we're going to go through exactly how he's taking apart her case, why her retaliation theory really doesn't hold water, and why her reliance on California law is fatal in a New York courtroom, and why even her own sworn testimony undermines her story. And I'm going to be reading you the quotes straight from his court filings. And so you can see how his defense is actually dismantling her case in real time. So, what Blake is alleging against Mr. Wallace is that she says that Wallace and others launched a retaliation campaign. That's her phrase. And she accuses them of spreading stories that painted her as rude, that marked her film marketing as tone deaf, and that suggested she didn't take domestic violence seriously in promoting her project. She claims this wasn't ordinary criticism. She's trying to tie organic backlash as it was a deliberate sabotage of her to discredit and bury her reputationally. Her theory is that Wallace and his co-defendants wanted to destroy her credibility before she ever accused Justin Baldoni of harassment publicly. The idea was that to make her unbelievable in advance, to silence her before she spoke. It's dramatic, but the catch here is that retaliation laws aren't built for hypotheticals. They're built on actual actionable actions that happen in adverse employment impacts to Blake. and she doesn't show any adverse employment actions that were taken against her. And Wallace's brief, points out her entire claim flows from reputational injury. And then he cites New York law considers claims sounding in tort to be defamation claims, where those claims seek damages for injury to reputation, or where the entire injury complained of by plaintiff flows from the effect of her reputation. And these are precisely the claim Lively alleges here. That's directly from his response. She's calling it retaliation, but he's saying if she's claiming it's an injury to her reputation, it's defamation. And he says throughout her entire response to him, she can't get around his claim of the defamation exception. So what is the defamation exception? This is where her case actually will start to fall apart, because he invokes what's known as a defamation exception. And in New York, how it works is if your case is really about reputational harm, then it belongs in defamation law. And you can't repackage it under other legal labels to avoid stricter rules around defamation, like the short statute of limitations, the requirement to identify specific false statements, and for public figures like Blake, the nearly impossible bar of proving actual malice. And if you notice, she's trying to frame this as reputational harm versus defamation when she calls this a smear campaign. And his lawyers say flat, because her claims against the Wallace defendants indisputably sound in defamation, she cannot predicate jurisdiction. Her entire framework is false light, FEHA, aiding and abetting conspiracy. Those two claims would fall apart if the actual claim sounds in defamation. And her own words, the ones in her complaint, keep tying everything back to harm her reputation. So they're saying that really what she's done here is packaged an entire lawsuit under employment law, when the truth is it's defamation being packaged as an employment law. That's why Wallace's team is mocking her response as almost non-existence. 2 paragraphs in a 31-page brief, she has no real answer to the defamation problem. And as they told the judge, that's silence will speak volumes. Blake's second major claim against Mr. Wallace is under California employment law, and it's the Fair Employment and Housing Act, or FEHA. There's one problem about using FEHA, because FEHA does not apply outside of California. California courts have said it again and again that if a plaintiff isn't a California resident, wasn't working in California, and the alleged conduct didn't happen in California, the FEHA doesn't apply, period. And here, Blake even admitted that the harassment she's complaining about happened in New Jersey. And then she went to New York to sue. And then now she's trying to drag in California law. And his lawyers pounced on that. And they told the judge, Lively's admission that FEHA does not apply to non-residents employed outside of the state when the tortious conduct did not occur in California is fatal, meaning the entire case is fatal. This wouldn't just make it fatal for Wallace, it would make it fatal for everyone. And it gets worse for her. Wallace's team continued and said, here Lively alleges no tortious conduct that occurred in California, and instead plainly predicates her claims against the Wallace defendants on purported New York-based overt acts. And that's devastating, because if FEHA doesn't apply, then her entire case and her entire legal framework collapses. She's basically using the wrong law in the wrong state. She has a problem here, a big one. She brought the case to the wrong forum. And we know why she brought it here. She forum shopped. Now, in order for her to try to save her claims in her response, she knows it's a problem. And what she tried to do was she tried to salvage her claim by arguing that the decision to retaliate was made in California. And she claims that because Wayfair is a California-based company, and because their lawyers are California-based, and they're the ones who recruited Wallace, that California companies paid his invoices. So because Wayfair's lawyers are California and because his invoices were paid out of California, that means California law should apply. But then she's wanting him to the New York court to have jurisdiction over him. On paper, it sounds clever, but his reply actually slices that all apart. And they pointed out that none of this ties Wallace himself to California. His alleged conduct, the media blitz, the statements, and the strategy all happened outside of California, which he denies he did any of those things. And they drove home this point by saying, even assuming the actions of Lively's employer were discriminatory, there are no allegations that the Wallace defendants knew that conduct was discriminatory or for the purpose of retaliation or harassment. In other words, even if someone in California made a bad decision, Blake hasn't shown Wallace knew about it or joined in it for a retaliatory reason. Without that, FEHA claim against him dies on the vine. And it's amazing to watch how they're systematically going through this, because this is giving a blueprint for how the same arguments can be made for other members of the Wayfair parties for their summary judgments. She has a really big problem with her retaliation theory, and it really doesn't add up. And his lawyers also go into that and say, even as setting aside the California problem that's in her case, her theory of retaliation doesn't even make sense. So what she was claiming is that Wallace and others spread stories that she was rude and that her marketing was tone deaf and that she didn't take domestic violence seriously. She says this was retaliation not because she had already spoken up. She spoke up privately, but it was to silence her before she ever did publicly. They were trying to discredit her in the off chance she ever said anything publicly. His lawyers point out the obvious, that that's not retaliation, that's speculation. And her retaliation requires a real protected activity and a real adverse action. And what she describes is hypothetical. And then her testimony, which was under oath, she admitted she couldn't name a single article or statement Wallace published that harmed her, not one. And so for someone claiming a near daily media blitz destroyed her reputation, that admission is fatal. His lawyers summarize it clearly. Her claims are nothing but defamation in disguise. And since she can't even point to a defamatory statement he made, what's left? Nothing. One aspect of Blake's case that has been so hard for me to actually understand is her contradiction in her story, in how she chose to react to when she claimed she was harassed and when the retaliation was happening. I was trying to put myself in my own shoes. You can put yourself in your shoes. But I would think if I was being harassed, I would want to get away from that person. I would not want to be near them. I would step back. I would want to create distance. I would want protections around me. I would not want to get closer to the people that are harassing me. But she did the opposite. So after she supposedly suffered harassment, she demanded more involvement in the film. She wanted more creative control. She wanted to be closer to the project. And by an extension, she would be closer to the people she was accusing, namely Justin. And that just doesn't fit harassment. And it raises questions. Was this really even about harassment, or was it about leverage? And was she using these allegations as bargaining chips to gain control of the movie? And that's going to be, if this goes to trial, something the jury will have to consider. His legal team frames the entire case as reputational gamesmanship, not retaliation. They remind the judge that Blake hasn't alleged any acts by Wallace that would even qualify as harassment or retaliation under FEHA. As they put it in their response, additionally, even assuming actions of Lively's employer were discriminatory, there are no allegations that the Wallace defendants knew that the conduct was discriminatory or for the purpose of retaliation or harassment. She's bringing him into something that he has nothing to do with. That's what they're telling the court. And truthfully, Blake is the one that created this entire mess where he is having to frame this by teasing out all these different states and all these different laws and FEHA from New York and all of these components, because Blake forum shopped point blank because of how she obtained her evidence for what she was able to file with the CRD in California. So she files a lawsuit in New York, not in California, after filing a CRD complaint in California. And it's because New York would let her use a subpoena without notifying anyone. This is how she obtained Jen Abel's phone. In California, the law would have required her to notify anyone impacted by the subpoena, including Wayfair and Jen Abel. This evidence grab never would have happened. And that's forum shopping. So when it comes to Jed Wallace, her pleadings show he was brought in by California insiders. As the brief says, Lively alleges the inverse, that the Wallace defendants are agents of the co-conspirators, who are California residents. And the law is clear. Courts have declined to find jurisdiction, whereas here, the non-domiciliary defendant acted as an agent of the domiciliary. Even Blake admits that the center of this so-called scheme wasn't even in New York. Wallace quotes her brief where she says a significant part of the retaliatory scheme was all carried out by California-based persons in California. But then she used New York subpoenas and filed in New York and pins the plan on California people. And her forum shopping is ultimately what's gutting her case because it's her choice to go to bypass laws in California that forced her to bring the case in New York. And now that shopping she did is creating fatal flaws in her case against Wallace. And it will create the same flaws against her cases against Wayfair. The legal team that Jed Wallace has hired has been incredible, in my opinion, by far the most effective in getting their points across to the judge because they are powerful in how they target all aspects of her case. They are not just fighting her on jurisdiction here, they're also going against her entire claims. And even if they hold water, and if they can even pass a motion to dismiss because she failed to state these claims properly. On the jurisdiction, he says she's got it all wrong on agency because it's backwards. And none of this happened in New York. But yet she wants New York law to apply here when she says she says New York, California law applies. On FEHA, he uses her own words against her and says that she admits that her claim is fatal because courts do not allow anyone that doesn't live in California to benefit from California law. On retaliation, he also exposes the hole in her story that she never engaged in a protected activity before the supposed retaliation. On knowledge and intent, the heart of aiding and abetting, he cuts it off and he says there's no allegation that the Wallace defendants knew that the conduct was discriminatory or acted for the purpose of retaliation or harassment. He's using less pages to cover more distance than Blake did in 31. It's strategy, it's not volume. His points are landing like a scalpel, just sort of slicing away another piece of her case until there's nothing left standing. The judge may not rule on this failure to state a claim or the jurisdiction, but the judge, he's giving the judge so many different ways to get this case dismissed. I don't believe it will survive his motion to dismiss. So where does this leave her in terms of the case? I think it'll be dismissed. Her retaliation claim is hypothetical, and she'll have to prove that she actually engaged in a protected activity, which is highly debatable because she never filed an HR complaint. And the 17-point agreement she relies on doesn't specify what overt acts occurred. Her FEHA claim is really, according to Wallace, defamation claims disguised, but it's transparent. And her own testimony admits that she can't name anything that Wallace did to harm her. He doesn't just poke holes at her case, he basically just levels it all. He just demolishes it. It's like he put a stick of dynamite on her case and the entire case just fell to the ground. His lawyers tell the judge because her claims against him sound in defamation, she cannot predicate jurisdiction. And they close the door with that jab that we started in the beginning that her two paragraph attempt in a 31-page brief to overcome the defamation exception is hardly a response at all. That's not a legal argument. It's really that they're sending a warning shot to Blake that her case is collapsing. He's not just defending himself, but he's dismantling her entire case. And he's giving Wayfair, like I said, a blueprint for what they can do when they go for a motion for summary judgment. She brought this to the New York court that has an exception for defamation that doesn't exist in California. She screwed up royally, and his attorneys were brilliant. I have a lot of faith after reading this. I know a lot of people have been feeling really bad lately, but trust me, just because she is winning in certain places in discovery doesn't mean she's winning her case at all. So tell me what your thoughts are in the comments below. Let me know if you think the judge is going to buy these arguments. And do you think this will help Wayfair also win their case against Blake? Make sure to drop all the comments below, hit the thumbs up, and subscribe to my channel. Thank you so much for watching. Bye, besties.